So with that, I'll introduce Adrian Bailey, who's a principal of our firm and runs our Sydney office, amongst many other things in the firm. Adrian has a Master of Taxation and regularly presents for both our LRC workshops and breakfast seminars, as well as at the Tax Institute, CPA, and many other places. So I'll hand over to Adrian to take it away.
Thanks, Paul. Welcome to everybody to our virtual workshop today. As mentioned by Paul, we're going to be talking about death and asset protection on the basis that asset protection doesn't end, or asset protection considerations don't end just because somebody has passed away. And what we generally focus on is making sure that whatever is left behind, and no matter how that is held, and we'll go into the different methods of holding assets, that's protected for the benefit of the next generation and generations after that. Our agenda today, we're going to cover off on a few things. So we're going to just have a very brief recap on what wills do and don't cover, and then have a look at the version of testamentary trust that we use most often, being our Bloodline Will Trust or our Bloodline Testamentary Trust, and to go through the features of that and why it's drafted in a particular way. We're going to cover off on taxation of testamentary trusts. Not going to have a look at taxation of the estate, but just going to have a look at the way that they are taxed, and in particular in relation to some recent changes that have come through following the May 2019 budget. One of the questions clients often ask is how safe these sorts of structures, what form of testamentary trusts are from any family court action. And we're going to have a look at one of the more relevant cases on point in that, as well as some follow-up cases to see why we can still offer protection from the family court. We'll have a case study running through the presentation. So just to put a little bit of meat on the bones in terms of the sorts of things that we're talking about. So we'll have a look at the different ways of structuring that within the case study, as well as having a look at what to do with existing trust assets, and then also superannuation. So superannuation, having a look at things like binding death benefit nominations, as well as other things that potentially could be an option for clients in particular circumstances. So that's what we're going to cover today. As Paul mentioned, anytime you've got questions, just feel free to shoot them through on the chat function. Happy to take them at any time, and Paul will butt in at an appropriate time to ask me that question as the moderator. So I mentioned our case study, so just as I said, to put a little meat on the bones in terms of some of the concepts that we're going to be talking about. We have the Harbour family. Mum and dad, 3 kids. So the old school nuclear family that you don't see as often these days, but that's our example for us today. In terms of their personally held assets, they've got the family home, holiday home, and cash in their personal names. They've got superannuation. They've got a balance of $1 million each. And they also control a family trust, which holds units in a unit trust that operates a business, as well as shares on the ASX. So having a look at that, what jumps out straight away is that we've got really 3 different classes of assets there. We've got the personally held assets, so they will form part of the estate. We've got super, which is something that's outside of the estate and something that our will cannot deal with. And then we've also got the trust. And again, will can't deal with trust assets. So we need to make sure that we deal with the control mechanisms rather than the assets themselves. In terms of the wills themselves, so the personally held assets that we listed on the previous slide, being the family home, the principal place of residence, as well as the cash, those are the things that will constitute our estate if we were to pass away. There's a small proviso on that, which I'll come back to in terms of the property holdings. So that's what our will deal with. Our will can only ever deal with personally owned assets. It's unfortunately still not too rare for us to come across some estate planning documents that are attempting to deal with other assets, such as company-held assets or trust-held assets or superannuation. And the reality is that they're just not effective. So unfortunately, you do come across those. And it's not just the post office wills, which we find contain those, but quite often wills drafted by lawyers are trying to deal with assets that they can't under the will. Just a reminder, doesn't include trust and company-owned assets. Of course, we could deal with the shares or units in a unit trust if they're held by an individual, but otherwise the assets themselves of those entities can't be dealt with via your will. Superannuation is another form of trust, and it again sits outside of our estate, so we can't deal with that in the will. Of course, In some circumstances, if it's appropriate, we can have our superannuation death benefit paid to our legal personal representative, and then it will be in the estate. However, we can't make a direction via our will in terms of the payment of our benefit. That's dealt with separately, which we'll come back to later in the presentation. The other thing, and I mentioned the proviso there, are assets owned jointly. So in the case of the Harbour family, who have the main residence or the family home and the holiday home, if that's held jointly between mum and dad, then under the rights of survivorship, if one of them passes away, their interest automatically reverts to the other. So it's not actually dealt with under your will if we hold it as joint tenants, and same goes for joint bank accounts and those sorts of assets. So what that means is that if we, again, coming back to the earlier slide, if we have a look at our estate, if the family home and the holiday home are owned jointly, then really all we've got left is the cash in their estate. And one of the questions and one of the discussions to have with clients is about, well, do we actually want to deal with that half of the family home or holiday home if one of you were to pass away? And if that's the case, and I will come back to that later in the presentation, but if that's the case, then we'd look at severing the tenancy to tenants in common. That way, we can deal with that half of the estate as opposed to it being held jointly. Very common client objectives on this slide. So one of the first ones is to make sure that we have an effective will or effective estate plan. So to ensure that our assets are adequately dealt with on our death. And then the one that's what really most clients come to talk to us about in this sort of scenario is to make sure that their assets are protected for future generations. So after they're gone, whatever wealth that they have generated is protected not just for the benefit of the next generation, but the generation after. Share market and those sorts of investments have certainly taken a beating recently. However, the reality is that Australia is a wealthy society and becoming wealthier, and so our asset pools are becoming bigger. So with that, more clients are concerned about making sure that whatever they are providing is protected in the future. And whether that risk comes from in terms of business risk of their children or some sort of left field claim or family law claim, it's all about making sure that people outside the family, and family, of course, can be defined a number of ways, but people outside the family do not get their hands on those assets. One of the other things, and it's quite often more the advisor that's concerned about this rather than the client, but some clients are concerned about it, to make sure that we've got maximum tax effectiveness and flexibility. So with our theme that we've been running over the last few weeks in terms of asset protection, we're obviously talking about death and we're talking about protecting our estate. And to do that, we can go one of two ways. We can either leave our estate to an existing trust, so an inter vivos trust, one that's created during our lifetime that we may have for investments or something along those lines. So in the case of the Harbour family example, it could be the Harbour Family Trust, remembering that it holds shares and units in a unit trust. Or we can establish a trust under the will. And that's where the term testamentary trust comes from. It's a trust that's created via the will. The reason that trusts are used a lot for asset protection, and the way I explain it to clients quite often, is that we can control the assets and we can benefit from the assets. But if we get sued or if we come under attack, the assets are not necessarily exposed and are safe. And that's the main reason that you use trust in asset protection, to make sure that we can control those assets. But if we're a trustee or a beneficiary or a principal or appointer, as we have no ownership interests in a fully discretionary trust, it does not matter if we get sued in terms of those trust assets. So whatever we're leaving behind for the next generation, we want to make sure it's protected, whether that's going to an existing trust or a testamentary trust. As long as it's fully discretionary, that will achieve our purpose for the clients. Of course, there are differences between the two. And the main two differences is that there's some taxation differences for testamentary trusts, which we'll come back to. And that if we're drafting our testamentary trust from scratch, we can often implement better asset protection features than off-the-shelf discretionary trusts that we might have got from a discretionary trust deed provider. So one of the questions that we spend a lot of time with clients in relation to their estate plan is that when we're dealing with trusts, whether that's dealing with an inter vivos trust that we're leaving assets to, so a trust that's in existence now, pardon me, or whether we're dealing with a testamentary trust, most of the conversation we have with them revolves around who is going to be the trustee or trustees of that trust. Of course, we can have an individual or corporate trustee. In the case of a testamentary trust, because the trust doesn't come into existence until the death of the will maker, unless we have a spare company lying around that we're happy to pay annual ASIC fees, it's very likely that in the first instance we will have individuals as trustees of that testamentary trust. And of course, they can then change that at a later time to a company because it's best practice to have a company acting as trustee of any trust. Whatever we're doing in terms of that individual trusteeship, or if we're dealing with a company trustee, we will always talk to the clients about the involvement of an independent co-trustee. And the main reasons for that is, one is it adds further protection from a family law claim. And we'll come back to that in terms of some of the cases and what they say about that. And the second thing is it allows somebody to ride shotgun. So in particular, where we're dealing with a testamentary trust, we want to have a discussion with the client about having an independent co-trustee there to ride shotgun to make sure that their wishes are followed. Of course, independent doesn't mean somebody like the public trustee or ANZ trustees. It quite often, when we're discussing this with clients, it will be that we suggest that it's their current advisors, whether that's accountant or financial planner or lawyer. A few reasons for suggesting a person like that. Usually they're a professional operating under a code of ethics. And quite often, if they've been a long-term advisor, they have a good knowledge of the client's financial affairs, as well as knowledge of their personal affairs. If we're appointing an independent co-trustee, quite often that's appointed with the children, for example, if we're dealing with a testamentary trust. In terms of doing that, we will also quite often limit the role of the independent trustee to what you would call the major decisions. So on a day-to-day basis, the children have control and management of the trust. However, if there are ever any major decisions to be made, they have to get the tick in the box from the independent co-trustee. And that's a way of building in that protection of having an independent co-trustee there, but not having issues in terms of having somebody who being called upon all of the time. So, as I mentioned, that's very likely going to be a lot of our conversation with the clients is about who are these people, and then often when doing estate planning, you're looking at substitutes or backups, so to speak. One of the good things about having an independent co-trustee being a professional is that allows us to build in some succession for them. So if they're not around, it's the next most senior person in their firm and so on. So that's another reason to potentially appoint somebody like a trusted advisor as an independent co-trustee. Of course, anybody that we're thinking of appointing to a role within a will, whether it's executor or whether it's trustee of a testamentary trust or whether it's another role, guardian of children, we need to have a chat with them first to make sure that they're comfortable to take on that role and that they're happy to do so. So turning to the Bloodline Will Trust or Bloodline Testamentary Trust, that's the trust that we use most often in our estate planning documents. So it was created by the firm in the early 1990s and was a direct response to concerns by rural farming clients about the impact of divorce on their children. So at the time, the firm was doing a lot of work in North Queensland. And if you've ever been to North Queensland, particularly on the coast, you would have seen a lot of sugarcane. And if you're unaware, predominantly Italian immigrant background in terms of the people farming that sugarcane. So they were having a lot of sons, not so many daughters. The other daughters that were around or ladies that were around weren't thinking they were appropriate. So they were having some situations where when the farm passed down to the next generation, there were issues in terms of divorce. So quite rightly, a lot of the parents were concerned about that if they went, that the farm would go to somebody other than their sons or daughters. So you may or may not have seen this before, our triple tragedy, or heard us tell the story. It's something that was told over a bar in North Queensland by a client. And like many things, it's a story, but it's a good example of some of the things that can go wrong. And if we pull up and if we have a look at each step, at each of these steps, something different could have been done. And if the clients and the extended family had further considered asset protection at each of these steps, we would have had a different result at the end. But the triple tragedy story, we had mum and dad running a farm, in North Queensland. That's where the story comes from. And they had a son who was working the farm. Mum and Dad are getting on, and as part of their estate and succession planning, and to give the son a little bit of certainty, they decide to gift half of the farm to the son. Reasonably common strategy in rural areas, because there are some concessions there in terms of tax concessions that allow you to do that at no tax. So son takes on half of the farm. He's now the legal owner of half of the farm from Mum and Dad. The next year, the son gets married to his wife. Nothing really untoward there, not a lot, but well, perhaps there were some things that could be done in terms of protecting from the new wife. However, in this case, unfortunately for the son, in year 3, he was killed in a tractor accident. So the son didn't have a will. So under the intestacy laws, his estate passed to his wife, so the daughter-in-law. So Mum and Dad now have the situation where they own half of the farm and the daughter-in-law owns the other half. Okay, they love their daughter-in-law. They enjoy her company, but they're starting to recognise that in terms of the planning that they could have done or should have done, they're getting themselves into a bit of a sticky situation. Unfortunately, it gets worse. And the daughter-in-law was killed in a car accident a year or so later. Again, she didn't have a will, and her interest in the farm, so half of the farm, went to her parents who lived in Adelaide in South Australia. So in 4 short years, we've gotten the situation where Mum and Dad own the farm wholly, to half of it being owned by, in effect, their daughter-in-law's parents. Now, what happened in this situation is that Mum and Dad had to buy the farm back. And you can see both sides of the table here. The daughter-in-law's parents, they're obviously grieving. They've received half an asset. They wanted to be paid for half of that asset. They've lost their daughter as well. So Mum and Dad buying the farm back, we're left with a situation where they, not in effect, they had to buy back half the farm. As I said, all of this could have been avoided if we'd done some proper planning at each of these steps, if we'd had things like wills in place, if we'd reconsidered gifting half of the farm to the son and perhaps gifted it to a trust and paid the tax or did something else. So, as I said, the triple tragedy story, it's a good example of how failing to plan, means we end up in a pretty poor situation. In terms of the uses of our bloodline will trusts, and I'll go into some of the features in relation to them in later slides, but generally speaking, we use them in estate planning as a form of testamentary trusts. We don't have to use them as a testamentary trust. We also do use them for inter vivos trusts, so trusts that are established during a client's lifetime. And normally what we would do, we would establish one or more bloodline testamentary trusts under the will. I say one or more because we will have this discussion with the client, but often our recommendation is to have one trust for each child. So in the case of the Harbour family with 3 children, we'd be looking to have 3 testamentary trusts established under the will. We have 2 different types of beneficiaries in the bloodline trust. We have the primary beneficiaries and we have the secondary beneficiaries. So the primary beneficiaries are generally limited to the spouse, the surviving spouse, if only one of them passes away, children and their descendants. So hence the term bloodline. The key part of the trust is that with the primary beneficiaries, they are the only ones that can receive the capital of the trust. So if there's a distribution of capital, whether that's because of a sale or whether that's because the trust is winding up, then that can only ever go to the bloodline. Income can be spread to other people. But one of the first arguments from a family law perspective that we can have, if we're looking to protect the trust assets, is that spouse could never have received any of the capital of the trust. The other area that we use them is in what we call aegis will arrangements, which are contractual wills. And we'll talk about that a little bit later in our next webinar. We won't talk about it today, but that's when we're trying to look at making sure that we're protecting against an estate challenge. So how does a bloodline will trust work? As I said, capital can only go to the bloodline. Income can go to the bloodline plus in-laws and other beneficiaries. Income can also obviously go to the bloodline. So if we look at it on a slide here with our diagram, in effect, we're building a wall between the family and everybody outside of the family in case there's a divorce or some other sort of claim against the beneficiaries. I mentioned that we discussed taxation of testamentary trusts. So in a normal inter vivos trust, any distribution to a minor beneficiary above around $600 is taxed at the full marginal rate, so not very tax effective. However, that rule doesn't apply to what's called accepted trust income. So income which is from a trust created under a will is accepted trust income under Section 102 AG2A. The end result of that is minor beneficiaries can have the adult threshold and rates. So in effect, we can have $18,000 tax-free to each of the minor beneficiaries. So if we have a number of grandchildren, obviously that can be a fairly large tax saving if we have a lot of income being generated within the testamentary trust. Of course, wherever there's tax benefits, there's also going to be some tax planning. And one, it's a little bit old now, but First's case is a relevant case on point, where we had a testamentary trust established. Some enterprising lawyers had gone to see Mr. First in hospital and had him create a will under which a number of testamentary trusts were created, each with a nominal amount of money in it. Unsurprisingly, one of the lawyers took over one of those testamentary trusts and then transferred his practice interest into the trust. He then treated any income being derived from the practice as accepted trust income and distributed to minor beneficiaries. The tax office didn't like that. We ended up in court where the federal court decided that under Section 102 AG, it can't just be assets that come down under the estate. So if those assets are changed or if they are modified, or in this case, the trust went and borrowed to acquire the practice interest, then those are assets held under a trust created by a will. So they are accepted trust income. Following First's case, we had some legislative change to deal with non-arm's length income arrangements. But since that time, in First's case, 20 years old these days, not much change until the May 2019 budget, when we had draft legislation which has now come into effect as of 1 July, which confirms that income, accepted trust income, can only come from assets that pass under the estate or replacements of those assets, or accumulation of income from those assets. So we can't have the scenario where, as in First's, where we borrow and we go and acquire a new asset. We could, of course, if we had sufficient assets in the trust, we could sell down those assets and use the cash to buy the practice interest, and that would still be accepted trust income. So some tightening there, but not the end of the world, and certainly a tax advantage if we're able to use testamentary trusts. In terms of continuing to use them, one of the questions clients will always ask is whether these are protected from family law claims. It's clear under the case law that a properly drafted trust continues to offer significant asset protection benefits, particularly in relation to testamentary trusts. And it's also clear in terms of the cases that properly set up and administered, the family court cannot barge through a bloodline will trust and get access to those trust assets. And to have a look at that, we can have a look at some of the trust busting powers of the family court, as well as have a look at some of the more relevant cases over the last few years. When I say last few years, one of them's getting on to 10 plus years now. So as cases go, that's relatively recent, but it's clear in terms of the current family court standing. So the trust busting powers of the family court are to either treat assets as either property of the marriage or as a financial resource. If they're treated as property of the marriage or relationship, then they can make an order to divide that. They can set aside transactions that are done in order to anticipate a family law claim. They have the power to declare a trust or an arrangement a sham, and the power to alter the ownership of a third party. So if they decide that a trust is property of the marriage, or the trust assets are property of the marriage more precisely, then they can make an order to alter the ownership rights in relation to that. The most relevant case in relation to this and what really led to an expansion of the family court in terms of trust assets was Kenan Spri. So we had Dr. Spri, who was a tax barrister. He married in 1978, and they had 4 daughters from the marriage. A little bit unusually, he was the settlor and the trustee of the trust and had the power to vary the terms of the trust. You're unlikely to find that in a deed due to the revocable trust provisions within the Tax Act. But in this case, he was both settlor and trustee. During the marriage, he transferred substantial assets from his personal name to the trust. And that's one of the things that really differentiates Spri as well. We've got a scenario here where he transferred the assets during the marriage. And if you're talking to a client about that and they ask, well, is this going to protect it? If their assets have been built up during the marriage, the short answer is no. But anyway, that's what he did. Sometime later, the marriage hit the skids, Dr. Spri was unfortunately caught out having an affair. And what he did in order to address that, who obviously became fairly bitter, was he excluded Mrs. Spri as a beneficiary of the trust. He then also transferred the assets of the trust to 4 separate trusts that his daughters controlled, with both him and Mrs. Spri having no position within those trusts. The court very quickly unwound that. We mentioned the power to unwind transactions done in anticipation of a family law claim. The marriage was already in trouble, and Dr. Spri only did this to try and hide assets. So with that, the court also went a little bit further and examined the original trust and said that his power of appointment to appoint trust assets to Mrs. Spri, together with the fact that he was the trustee and his own interests, it fell within the definition of property of parties to the marriage. They also said Mrs. Spri's right to due administration of the trust was property of the marriage as well. It's not an unsurprising decision in Spri, because when you think about it, he did all of these things once the marriage was already in trouble. And so the family court was, generally speaking, going to try and slot him to a certain extent. Of course, since Kenan and Spri, all the family lawyers started jumping up and down and cheering from the rooftops, saying that's the end of trusts for asset protection from family courts. The reality is not that, and that they still provide protection. Like any case, different facts lead to different outcomes, but we need to consider proper structuring and administration of the trust. So just to point out in terms of some of the subsequent cases since Kenan and Spri, one of those is Essex and Essex. So in that scenario, we had Mum, and she established 2 trusts for her son, and she gifted assets from herself into those trusts. Now, the brothers were trustees of each other's trusts, and they were income beneficiaries of the trust as well, so of their own trust, so to speak. James, one of the sons, had a relationship breakdown. One of the stated objectives of the gift was to protect Mum's assets from his wife. That was clear on the evidence. And what the family court found was that as James was neither a trustee director nor an appointer, they had companies acting as trustees, he had no control and the trust was protected. So we can see if we structure correctly, we're still going to get protection in terms of family law claims. And that's certainly been the case in these other cases that have been heard since Kenan and Spri. All of these have led to the family court not interfering with trust assets. There's a more recent one, not on the slide, only just last year, which went along the same principles. So we can see that's consistent there, in that as long as we have our trust structured correctly, remembering that our bloodline will trust, we can only have capital going to the bloodline descendants. We'd have a look at making sure that we've got the right people in control of the trust, and I'll come back to that. Then we've got strong protection from a family court claim. The other thing, even in Kenan and Spri, was that the court found that part of the trust, which had come via an estate, was still excluded from the family court claim. So even in that case, despite all of the goings on by Dr. Spri, it's still clear that in the right circumstances, testamentary trusts provide excellent protection from a family law claim in the next generation. In terms of maximising that protection and the best practice of structuring our testamentary trusts, obviously we want to have joint trustees or appointers for the trusts. In a perfect world, much like in Essex and Essex, we wouldn't have the children as trustees at all of their own trusts. However, most clients still want to maintain some form of control, even if it's shared control, with their testamentary trusts. So we can't always get to that perfect world position. The best that we can do in those circumstances is making sure that the child needs to have an independent co-trustee appointed, and in any of those, as we say, major decisions, the independent co-trustee must agree to it. Of course, considering our theme of asset protection as well, we want to have separate trusts for separate assets, have clear intention to benefit our bloodline only, and that's part of the structuring of the wills. It's clear that it's only to benefit the bloodline. And then also thinking about pre-relationship assets and whether they can be quarantined. In terms of testamentary trusts, everything is a pre-relationship asset because it's coming down from a prior generation. So we want to make sure if that occurs, it's not going to the individuals, it's going to a testamentary trust. Post Kenan and Spri, we of course review our trust deeds all the time, but we decided to make some specific changes to the trust deed post Kenan and Spri. One of those to say that if a beneficiary takes what you consider to be an attacking position against the trustee, they are automatically removed as a beneficiary. The other one to specify on that second point from the High Court that a beneficiary's right to due administration does not form part of the trust fund, so it can't be property. Returning to the Harbour family, in terms of their structure, what we would very likely do in terms of mum and dad's will is we would establish 3 testamentary trusts, in this case 3 bloodline will trusts. And each of those trusts would receive a third of the estate on the assumption that the client's instructions are that each child shares equally. In the first instance, the trustee would be the other parent, so the survivor, and then child 1, child 2, child 3, and then their children and grandchildren would be the trustees. Of course, considering our advice and our recommendations in relation to independent co-trustees, at each of those levels, we would recommend that there's an independent co-trustee there to ride shotgun. One of the things I mentioned earlier is the fact that jointly held property does not form part of our estate and goes to the survivor. One of the discussions that we should be having with clients is whether they want that to occur. And I say that on the basis of we have to take estate planning as if we're going to get run over by a bus today. And if that happens, most of our clients, the reality is that there may be a new partner in the future. So if that were to occur, if they have a new partner and they've received their entire estate, then that potentially could be at risk. And if that occurs, and when I say at risk, I mean from a family law breakdown, and if that occurs, it may be that the children of the first marriage miss out on some form of the assets that have passed. When you have this discussion with most clients, they'll understand where you're coming from. And most of them will say, well, we trust each other. However, we just want to make sure that at least half of our estate is protected if we were to pass away. So in that circumstance, we would sever the joint tenants, so they would become tenants in common, and we would be able to deal with the main residence and the holiday home. On the main residence part, also one thing we need to discuss with the clients is issues in relation to the main residence exemption for CGT purposes, and then also things like land tax if it's going to be held by a testamentary trust. So all of those discussions we'll need to have with the clients to make sure that we develop an effective estate plan that meets their needs. But that's normally the way, together with the addition of the independent co-trustee, the structure for the Harbour family would be recommended in terms of their personal estate. Of course, they don't just have personal estate assets, they also have the Harbour Family Trust. With existing trust assets, it's more important to pass control through the appointer or the principal role to the right persons, because we're not actually dealing with the trust assets. We may not necessarily want to wind up the trust. We might want to keep it going for tax reasons. So with the Harbour Family Trust, we would want to make sure that the first principals are mum and dad, and that the successor principals are the 3 children, Rachel, John, and Stephen. Of course, in that discussion with the clients about this, we need to ask them whether Rachel, John, and Stephen become successors once mum or dad pass away, or only on the passing of both of them. And there's pros and cons to both approaches, of course. Having them join if only one passes away will mean more protection that mum or dad aren't going to get taken advantage of in the future. However, as long as they're not taken advantage of by the children, of course. However, there are some clients have concerns about their children becoming co-controllers of the trust assets. So it's another discussion to have with the clients. And as I said, most of our discussions revolve around trustees or control and looking at the different ways that we can approach it and the pros and cons of each. One of the other things to consider is whether we do this now by way of a deed, amending the principal clauses, or whether we do it in the will. Now, most modern deeds will have a provision within them that allows you to appoint a successor principal or appointer by your will. And we can certainly go down that road. However, the issue that we have with that approach, and why we would always suggest we do it by a separate deed, is that if we do the will and we have Rachel, John, and Stephen being appointed under the will to successor principals of the Harbour Family Trust, we don't know what happens when mum and dad leave our office. They may go, extreme example, they may go around the corner, get another will drawn up, and that lawyer doesn't cover off on who becomes the successor principal in the Harbour Family Trust. So it's always better to set it, in our opinion, to set it in stone and have a separate deed so that if there are changes in the future to the will, if that's inadvertently missed, we're not going to have any issues with control of the Harbour Family Trust. superannuation and estate planning. So the main issues with superannuation relate to what you'd consider to be the legislative overlay. So because of the way the legislation is written, there's only certain people, and so dependents, that we can pay our superannuation death benefit to. So we don't have the same sort of flexibility to deal with our assets because of the rules of the funds and the rules of the legislation, such as the Superannuation Industry Supervision Act and the Income Tax Assessment Act. Of course, with that lack of flexibility, it means that we may not be able to do some things that the client wants to do. So say, for example, they wanted to give their super fund to their grandchildren. Unless they were dependents, which they are unlikely to be, they won't be able to give their superannuation benefit direct to the grandchildren. They can, of course, maybe pay it into their estate via their legal personal representative and for it to go to the grandchildren from there. But there are often circumstances where we don't want to put any more money into the estate than is absolutely necessary. And that's generally speaking when we've got concerns about an estate challenge. Super is held outside of an estate, New South Wales aside, and I'll make some comments on New South Wales a little bit later. Generally speaking, we don't need to think about super if it's an estate challenge situation, because we can just have it paid directly to a person under a binding nomination, and then it stays outside of the estate. Of course, different levels of taxation in a superannuation fund. If the fund is not in pension phase, or if it is over $1.6 million, then we'll have tax on the realisation of investments. And we can also have taxation on the payment of benefits to members or the beneficiaries. If the payment is made to a death benefit dependent, then that tax is nil. So that's spouse, children under 18, a financial dependent, or someone in an interdependency relationship. No tax on that payment. Or if it goes to anybody else, and the reality is that aside from the spouse, most times, in most situations, it's going to children that are over the age of 18, there will be a proportion that's taxable. So that's just something that we have to deal with. Of course, if we know when we're going to die, so if we have the situation where the client is terminally ill, for example, it is a valid strategy to remove all of our super out beforehand to avoid that tax. But of course, not everyone knows when they're going to die or is in that situation and has the capacity to make that removal from the super fund. In terms of paying the actual superannuation benefits and making sure that they're paid to the right people, the general rule is that it's at the discretion of the trustee. However, that discretion can only be exercised, as I said, in terms of that small group of people. So spouses, children, interdependency relationship or financial dependents, or the legal personal representative or the executor. And the way that that's often done is by way of a binding death benefit nomination. So with binding death benefit nominations, the general rules for retail super funds or an industry super fund, for example, is that they lapse after 3 years. Of course, there's also going to be other requirements in terms of the form that you have to complete, the witnessing requirements, all of those contained within the fund deed on the fund rules. For a self-managed super fund, it does depend on the super deed and can also be non-lapsing. So we can prepare a non-lapsing binding death benefit nomination, which will last longer than the 3 years. Also, it's a lot more flexibility with the self-managed super fund in that we can set out whatever rules that we want in terms of how we make a nomination, whether it's binding or non-binding, how it can be revoked. And of course, that can lead to some different strategies that we can use, one of which we'll examine a little bit later. Of course, the other thing, though, it means that we can't just trust the fact that all deeds are the same, because they're not all the same. Of course, there's a lot of similarities, but we still need to read the deed to make sure we know how we make this nomination and we make it effectively. Because if we don't have an effective nomination, then we may be in the position where our super isn't going to go where we want it to be. Obviously, I mentioned one of the main issues with the binding death benefit nomination, it has to be to an eligible recipient. So again, using the example of the grandchildren, we can't give it to them. The disadvantage is kind of the flip side of the main advantage in the main advantage of a binding death benefit nomination is that we have certainty. And if it's non-lapsing, we can kind of set and forget, and we know that it's going to get paid to that particular person. However, that's also a disadvantage. Like many things that are set and forget, circumstances change. And unless we review it, we may find ourselves in the situation where the payment is being made to a person that we really don't want it to be paid to. So say, for example, payment is going to a child and at the time of the payment, the child is just about to enter bankruptcy or has entered bankruptcy. So those sorts of issues are really the main disadvantage of a binding death benefit nomination. Sometimes we obviously need to think about asset protection for the beneficiaries. So say, for example, myself as a lawyer, I don't necessarily want to receive a payment in terms of a death benefit. I mean, I certainly don't want to receive one anyway, because that means somebody I know has died. But I don't want to receive it in my own name because I'm in an at-risk profession. So bearing that in mind, what are the other sort of things that we could have a look at? Of course, one of those things is that we could pay it into the estate. However, and from the estate, it could go to a testamentary trust, for example. However, of course, there are certain circumstances where we don't want to pay it into the estate. And as I mentioned before, that's generally speaking where we've got concerns about an estate challenge, or perhaps we've got a blended family, for example. So we want to make sure that our funds go elsewhere or not into the estate. I mentioned New South Wales have some particular provisions, and they're called the Notional estate provisions. And what they do for an estate challenge is that they can, in certain circumstances, they can claw back assets into the estate that wouldn't normally be in there. So assets held in trusts or assets held in companies, they can form part of the estate challenge. So it flips estate planning on its head to a certain extent. One of the areas that's been a rich vein for lawyers in this area in terms of those estate challenges is superannuation. Because we've had cases in New South Wales where we've made the nomination, that's been subject to clawback, and when we haven't made the nomination, that's been subject to clawback. So one way that we could address that, particularly to deal with that, is that we could hardwire the deed. And by that I mean our deed will normally allow us to have provisions to make a nomination so our death benefit is paid. We could actually amend the clauses to set out who that's paid to. So say, for example, we could change the deed to say that on the death of Adrian, the payment goes to Sarah. So if that's in the deed, that's the way it will occur. If we did that more than 3 years before Adrian passed away, picking on myself, then that would be safe from the New South Wales Notional estate provisions. There may be other reasons that we want to hardwire the deed in other jurisdictions, but that's one of the examples of something that we could do other than a binding death benefit nomination. The other thing that we could do is what we call our assignment of proceeds. So what that deals with is assigning the death benefit payment, so the actual proceeds that we receive, to something else. And usually we'll assign it to a trust for those asset protection reasons. The sort of scenario that we would look to utilise this sort of arrangement is where we have no other choice, in that we don't want to pay it into the estate because we're concerned about an estate challenge. And we don't really want it to go to the person because perhaps they're under attack themselves. So what we do in terms of this is we actually assign the right, we don't assign the right, we assign the proceeds to a trust. The reason that we do that is that we have an agreement to assign at receipt. So when the death benefit is paid, that's when it is assigned to the trust. That's supported by an irrevocable power of attorney and security under the Personal Property Securities Act, as well as usually a binding death benefit nomination. So, believe it or not, in terms of the Personal Property Securities Act, we can take a security interest over future property. And I'll come back to that in one of the later slides. But what it means is that the trust is now a secured creditor of us if we're receiving the benefit in the future, or we're down to receive the benefit. And as soon as that benefit is paid, it is automatically assigned to the trust. So in effect, it doesn't touch our hands. Now, in terms of taking that security, just a reminder, we're not taking security over the super fund. Obviously, we can't do that unless it's certain circumstances. We're taking security over the member. So this is where we've got a high-risk member that we don't necessarily want to receive the superannuation death benefit, but we've got nowhere else to pay it. In terms of in practice, the super fund with our member, we would have an agreement between them and the trustee of the trust, in this case a Bloodline Trust, to assign the proceeds being their death benefit payment when received. Usually we'll be doing this within a husband and wife type scenario, and the rationale behind it is that we want to get into a position where a third party, being the trustee of the trust, can enforce its rights in relation to the member. So, like in our other asset protection discussions, we want to be a secured creditor, and this will get us into that position, or get the trust into that position, I should say. I mentioned under the Personal Property Securities Act, a future interest is a securable right. So we can actually take a security interest over that future interest in the death benefit payment. And that allows us to be a secured creditor. So we're first in line if the payment is made, and if for whatever reason the payment isn't then actually paid on to the trust. We can take steps as the trustee of the trust to enforce that security. Of course, when dealing with these sorts of things, we need to think about tax. In this situation, we're dealing in cash when it emerges, not in the rights to the cash. So like with most things with cash, there's no CGT or stamp duty because that's all we're dealing with. So we can implement it without there being any tax issues in relation to the assignment of the proceeds. So as I said, that could be a strategy that, or not could be, that would be a strategy that could be used if we have a situation where we don't want to pay into the estate and we have a high-risk individual or an individual who's already under attack, and that's the only place that we can pay it. Of course, there could be other variations. If we had other siblings who were low risk, we could pay to them on the understanding that they repay to the other child or to the trust at some stage. Of course, that could lead to other issues. But this is a way of making sure that we're securing that superannuation payment and doing it in a way that we are a secured creditor. In terms of you'd look to implement that sort of arrangement with, obviously, people with large superannuation balances and quite often it's a blended family situation or there's a concern about an estate challenge. Because as I said, the alternative would be to pay it into the estate, but in a lot of circumstances, we don't want to do that for other reasons. So hopefully today I've been able to go through a few things in terms of outlining asset protection on death and the reason why we should use trusts for asset protection, whether that's a testamentary trust or an existing trust that receives our estate. Also been hopefully able to show how a properly structured trust can still withstand a family court attack in this situation. As I said, we're dealing with pre-relationship assets, being assets that are coming down from a previous generation, and they're held not just for the benefit of this generation, but for the generation after. And we're further strengthening that by having only primary beneficiaries able to receive capital as well as independent co-trustees. Of course, it's very important to properly document an effective estate plan in terms of the legal documentation. And we also need to consider trust assets if we have trusts in our client stable, as well as superannuation, and thinking about some of those other strategies, as well as also thinking about, well, a binding death benefit isn't the be-all and end-all, and thinking about some of those other scenarios about how it can be inflexible in certain circumstances. So I'm going to pass back to Paul to throw open the floor to any questions, if anybody wants to throw them in terms of...
Thank you, Adrian. We haven't had any questions come through. You obviously covered the topic very well. If anyone wants to put any questions through, please do so on the chat function or speak up. While that's happening, I'll just remind everyone that our feedback surveys will go out shortly. There is a new question on there as to how frequent you would like to see us continue with these. Please give us your feedback on all the topics and also what you'd like to hear about in the future. Just got one question which I'll deal with, Adrian, from Shane. Just says, what does PPSA stand for? It stands for the Personal Property Security Act. It's just a legislation that deals with securities over personal assets, so anything that is not land. Thanks, Shane. I guess thank you everyone for coming. If you do have any questions, feel free to hang on